Welcome back to the deep dive. Today, we're cracking open a subject that's absolutely fundamental if you want to understand how our justice system actually works.
That's right, we're talking about the law of evidence.
Exactly. I mean, how do courts figure out what really happened? What information can they actually consider? And, why? That's the core of evidence law.
And that's exactly where we're diving deep today. And look, we've got some fantastic resources guiding us.
Oh, yeah.
These are really invaluable documents made available by the University of London. They're specifically designed for educational purposes.
Right. For students primarily.
Yes, aimed squarely at helping students get to grips with the sort of essential building blocks of what can be a pretty complex subject. And, crucially, helping you prepare for exams.
That's great. We should also give a big shout out. This deep dive is brought to you by Sinorbit Academy Sri Lanka.
Absolutely. Sinorbit Academy, Sri Lanka.
And look, for all of you out there hitting the books, getting ready for exams, working through your studies, we're right there with you. Seriously, best of luck for your exams.
Yeah, really good luck you can do this.
So, our mission today, using these University of London materials, is basically to be your guides, right?
That's the plan. We're going to unpack the key concepts, the essential terminology, the language you need, the theoretical ideas behind the law, and also the practical procedural context. Where does this all actually happen?
Yeah, because it's one thing knowing the rule, another knowing how it applies in court. The goal is to give you a clear, comprehensive understanding. Think of this as maybe a shortcut.
A shortcut to getting well-informed on these foundational concepts, yeah. We've sifted through the source material you provided and pulled out what we think are the most important bits.
The nuggets, the key insights. Hopefully you'll have some real aha moments today that will, solidify your understanding right from the basics.
Okay, so let's jump right in. The absolute starting point, the basic principle for getting evidence into court, what's the prima facie rule?
Prima facie, meaning on the face of it.
Exactly. The rule is all relevant evidence is admissible.
Okay, seems simple enough. All relevant evidence is admissible. But there's always a but, isn't there?
There usually is in law. The crucial part is the qualifier. Unless an exclusionary rule or an exclusionary discretion applies.
Ah, okay. That unless is doing a lot of work there. That's where all the complexity, all the rules we need to learn comes in, right?
It really is. And understanding that initial framework relevant evidence is in, unless a rule or discretion keeps it out, immediately flags up three absolutely core concepts:
Which are?
relevance, weight, and admissibility. You really have to understand how these three are distinct, but also how they interconnect. They're fundamental to everything else.
Okay, let's break them down then, starting with relevance. The source material points out that relevance isn't quite as straightforward as it might sound.
No, it definitely needs a bit of careful thought. And the most widely accepted working definition, one everyone starts with, comes from a really classic case, DPP v. Kilbourne.
Okay, DPP v. Kilburn. Say that again.
DPP v. Kilbourne. It's a House of Lords case from 1973. And it was Lord Simon in DPP v. Kilbourne who gave us the standard definition.
Right, what did he say?
He said, and this is the key quote, "Evidence is relevant if it is logically probative or disprobative of some matter which requires proof."
DPP v. Kilburn. Got it. Logically probative or disprobative? Can we unpack that a bit? Probative and disprobative.
Sure. Think of probative as tending to show something is true. The evidence makes the fact you're trying to prove seem more likely.
Okay.
Disprobative is just the opposite. It tends to show the fact is false, makes it seem less likely. So relevance is essentially about a logical connection. Is there a link?
A logical link between the piece of evidence and the thing you're trying to prove or disprove.
Exactly. Does this information make the existence of a fact that needs proving more probable or less probable? That's the core question of relevance.
Okay, so using your example, if a key fact we need to prove is did the defendant have the knife, then evidence that someone saw the defendant buying that exact type of knife the day before, that would be relevant.
Yes, definitely. Because it's logically probative. It makes it more likely, logically speaking, that they had the knife at the relevant time. It has that logical tendency.
Right. And understanding why relevance is so fundamental, the source gives a couple of reasons.
It does. Firstly, the big one we started with.
Yeah.
All relevant evidence is prima facie admissible. If it fails the basic relevance test, generally speaking, it doesn't even get considered for admissibility under other rules. It's out at stage one.
Okay, the first hurdle. What's the second reason it's so important?
This one's a bit more subtle, but really crucial, and I think it often trips students up at first. The specific reason why a piece of evidence is relevant can actually determine which legal rules apply to its admissibility.
Whoa, hang on. So it's not just this is hearsay evidence, so the hearsay rule applies.
Yeah.
It actually depends on the purpose for which you're offering it, its specific relevance.
Precisely. Let's take the rule against hearsay. We'll cover this in detail later, but the basic idea is it generally excludes statements made outside of court if you're using them to prove that what was said is true.
Okay, makes sense.
So imagine someone said out of court, "I saw John running away." If the prosecution wants to use that statement to prove the truth of it, i.e. that John really was running away, then the hearsay rule might kick in and potentially exclude it.
Right.
But what if the reason you want to introduce that statement isn't to prove John was running? What if you just want to prove that the person who made the statement was, say, alive and capable of speaking English that specific moment?
Ah, so the relevance is different. You don't care if John was running or not.
Exactly. In that case, the hearsay rule doesn't apply because you're not offering the statement to prove the truth of its contents. Its relevance is for a completely different non-hearsay purpose.
Wow, okay, that's a massive point. So before you even jump to thinking about, say, the hearsay rule or any other exclusionary rule, you first have to ask, what fact is this party trying to prove with this evidence?
Yeah.
That tells you its relevance. And that, in turn, tells you which admissibility rules might even be in play.
You've got it. You need to identify what the evidence could potentially be probative of. And the sources rightly say that figuring this out, constructing arguments for or against relevance, it's a skill. It's not like a mathematical formula.
It relies on what?
Common sense. Yeah, largely. Common
Yeah.
sense or general understanding of how the world works, experience. You know, those background assumptions we use to decide what makes one fact logically point towards another.
Like your muddy example earlier, someone covered in mud.
Yeah.
Relevant to whether they were in a muddy field? Probably yes, common sense link. But if they work with clay?
Exactly. The context matters. It affects the logical connection. And the sources pose the question. How well is relevance actually defined in English law? The fact they ask suggests it's not perfectly clear-cut.
So that DPP v. Kilburn definition is the starting point, but applying it in specific cases can be complex and debated.
Definitely. It's often argued about in court.
Yeah.
So relevance, the logical connection. Now, what about weight? How's that different?
Weight, is it how strong the connection is?
That's it, exactly. Weight is about the strength of that logical connection. It's the probative value of the evidence.
Yeah.
If relevance asks, does it connect? Weight asks, how much does it connect? How convincing is it?
How much more or less likely does this evidence actually make the fact we're looking at?
Precisely. And who usually decides the weight of evidence?
That would be the jury, right, in a Crown Court trial?
Generally, yes. The jury are the tribunal of fact.
Yeah.
They hear all the admissible evidence, and they decide how much importance, how much weight to attach to each piece when reaching their verdict.
But judges do get involved in assessing weight sometimes. You mentioned exceptions.
They do, in specific legal situations. One key time is when the defense makes a submission of no case to answer, which we'll definitely come back to.
Okay.
And another really crucial one is when the judge is deciding whether to use their discretion to exclude prosecution evidence.
Ah, right. How does weight play into that judicial discretion? You mentioned balancing.
Yes. Under the Policing Criminal Evidence Act, 1984 PACE, particularly Section 78, the judge has a discretion to exclude prosecution evidence if admitting it would have such an adverse effect on the fairness of the proceedings that it ought not to be admitted.
Okay. Section 78 PACE.
Fairness. And when exercising this discretion, the judge often has to perform a balancing act. They weigh the potential for the evidence to cause unfair prejudice to the defendant against its probative value, its weight.
So to do that balancing, the judge has to assess the weight. They have to decide how strong the evidence actually is.
They absolutely do. They need to figure out how much probative value it has before they can weigh it against any potential prejudice. It's a critical part of that S.78 assessment.
Okay, this is clicking now. Relevance is the logical link. Does it connect at all? Weight is the strength of that link. How much does it convince us? And admissibility. That's the third piece.
Yeah.
Let's talk about admissibility and exclusion of evidence.
Right. Admissibility is the legal question. It's a matter of law, and it's decided by the judge, not the jury. This is the key difference from relevance and weight, which are more about logic and common sense applied to the facts.
So admissibility asks, forget relevance for a second. Forget weight. Do the actual rules of evidence permit this information to be presented in court?
That's the essence of it. Evidence could be incredibly relevant and seem really weighty, but still be inadmissible if there's a specific legal rule, an exclusionary rule that says, nope, this type of evidence in these circumstances is not allowed.
Like maybe certain types of hearsay or improperly obtained confessions.
Exactly. Those are classic examples of exclusionary rules. So remember the starting point. All relevant evidence is prima facie admissible unless. Admissibility is about that unless. It's the legal filter.
But you also said earlier that sometimes admissibility depends on relevance. How does that work again?
It comes back to that point about why the evidence is relevant. Remember the hearsay example?
Yeah, the statement, I saw John running.
Right. Is it admissible? Well, it depends. What's its relevance? Are you trying to prove John was running? Relevant for its truth. If so, the hearsay rule might make it inadmissible. Are you trying to prove the speaker was alive? Relevant for a non-truth purpose. If so, the hearsay rule doesn't even apply, and it might well be admissible.
Ah, okay. So establishing the purpose or the specific relevance is often the first step to figuring out which admissibility rule applies. Relevance is the gateway.
Often, yes. You need to know why it's being offered before you can apply the right legal test for admissibility.
Now, how does this admissibility question play out differently in civil trials compared to criminal ones? The source mentions a difference.
Yeah, there's a significant difference in approach. In civil trials, which are governed by the Civil Procedure Rules, or CPR, the judge generally has a much wider discretion to manage and exclude evidence.
Wider discretion how?
Under CPR Rule 32.1 Desan, that's CPR 32.12, the court can limit or exclude evidence, even if it's relevant and technically admissible, if doing so helps achieve the overriding objective set out in CPR Rule 1.1.
And the overriding objective?
Mm.
That's about efficiency and fairness, right? Dealing with cases justly and at proportionate cost. Rule 1.1.
Exactly. So a civil judge can effectively say, look, this piece of evidence might be slightly relevant, but hearing it will take 3 days, cost a fortune, confuse the main issues, and the potential benefit is tiny. For the sake of proportionality and dealing with this case justly overall, I'm excluding it under Rule 32.12.
So much more pragmatic, much more focused on case management in civil.
Generally, yes. In criminal cases, as we touched on, the judge's power to exclude relevant prosecution evidence is more constrained. It's primarily focused on that fairness balancing act. Does the prejudicial effect outweigh the probative value, the weight, often using that Section 78 PACE power?
Okay. Can we look at a couple of cases the source mentions that show judges wrestling with admissibility, maybe where weight was a factor?
Sure. The source highlights Wilson. That's Wilson 2008 EWCA Crim 1754. Remember Wilson?
Wilson, what happened there?
In Wilson, the issue was whether the prosecution could bring evidence that no similar offenses had occurred in the area since the defendant had been arrested.
Ah, trying to suggest his arrest stopped the crimes.
Exactly. The defense argued this evidence was inadmissible. They said it was too nebulous and prejudicial. Basically, it lacked specific weight linking him to the prior offenses, and it unfairly made him look guilty just because the crime stopped.
What did the Court of Appeal decide in Wilson?
They actually upheld the judge's decision to admit the evidence. The court found that in the circumstances, the evidence did have sufficient probative value, enough weight to be relevant and admissible. They decided it wasn't unfairly prejudicial or too vague. It had a logical bearing.
Okay, so Wilson shows that arguments about admissibility can really involve debates about the weight or probative value of the evidence itself. Was there another case example?
Yes, HSBC Asia Holdings BV v. Gillespie. That's HSBC Asia Holdings BV v. Gillespie, 2011 ICR 192 ET.
HSBC v. Gillespie, an employment tribunal case.
Yes, but Underhill J., as he then was, made a point relevant to admissibility discretion more broadly. He said that tribunals could exclude evidence that was, quote, logically or theoretically relevant, but was ultimately too marginal or otherwise unlikely to assist the court for its admission to be justified.
Too marginal or otherwise unlikely to assist the court. That phrase from HSBC v. Gillespie really captures it, doesn't it? Evidence might have some logical link, but just not enough practical value or weight to warrant taking up court time.
Precisely. It shows how considerations of probative value, usefulness, and maybe even efficiency can feed into admissibility decisions, especially where judges have that broader case management discretion, like in civil or tribunal settings.
Okay. So bringing it back to a key distinction, the source emphasizes for self-assessment, the difference between an exclusionary rule and an exclusionary discretion.
Yes, this is absolutely vital. An exclusionary rule is like a command from the law. It sets out a category of evidence, say, opinion evidence from someone who isn't an expert, or subject to exceptions, hearsay, and says this is generally out. Judges must follow these rules.
It's mandatory. And a discretion.
A discretion gives the judge leeway, some room to maneuver. They have to weigh up different factors like probative value versus prejudice under S.78 Pace E, or the overriding objective in civil cases under CPR 32.12, and then make a judgment call based on the specific facts and the principles of fairness or efficiency. They have the power to choose whether to admit or exclude.
Okay, that makes it much clearer. Rules are hard lines, usually with exceptions, while discretions involve a balancing act by the judge. And the source points to some further reading cases, Wilson again, Berry George 2007, EWCA Crim 2722, and Curley 1992 2 AC 228.
Yes, Wilson, Berry George, and Curley. It specifically notes the focus on the relevance aspects in Curley. These cases really illustrate just how tricky applying relevance and weight can be, and how controversial admissibility decisions can sometimes get.
Right, we've got the framework. Relevance, weight, admissibility, crucial concepts. To really operate within that framework, we need the right language. Let's move on to terminology.
Absolutely essential. Evidence law has its own specific vocabulary. If you don't understand these terms confidently, the rules themselves won't make much sense. The source provides a really good list of core terms.
Okay, let's go through them, define them, maybe give an example for each. First up, facts and issue.
Okay, facts and issue. These are the ultimate core facts that the prosecution in a criminal case or the parties in a civil case must prove to succeed. They are the central questions the trial is trying to resolve.
Like in a murder trial, the facts and issue would be, did the defendant cause the death? Did they intend to cause death or serious harm?
Exactly. Those are the key things the prosecution has to prove beyond reasonable doubt. In a civil breach of contract case, it might be, was their contract, was it breached? Did the breach cause loss? Those are the facts and issue.
Got it. The main points to be proven. Next, direct evidence.
Direct evidence is evidence that, if the court believes it, proves a fact and issue directly without needing any further reasoning or inference. It's straight proof of a key fact.
The classic example being
an eyewitness testifying. I saw the defendant stab the victim. If the jury believes that witness, that testimony directly proves the act of stabbing, which is likely a fact and issue. No logical jump needed.
Okay. Contrast that with circumstantial evidence.
Circumstantial evidence is different. It doesn't directly prove a fact and issue. Instead, it proves some other subsidiary fact. And from that fact, the court or jury is asked to infer or deduce the fact in issue.
So it's indirect evidence around the main point that lets you draw a conclusion, like connecting the dots.
That's a great way to put it, connecting the dots. It's like pieces of a puzzle that, when put together, suggest the main picture. The source uses a really clear, quick quiz example to contrast them in a murder case.
Oh, is that?
Direct evidence.
Yeah.
The witness saying, I saw the defendant stab the victim. Circumstantial evidence. A witness saying, I saw the defendant running away from the victim's house, covered in what looked like blood, just minutes after the estimated time of death.
Ah. So seeing them run away covered in blood doesn't directly prove they did the stabbing, but you're asked to infer from those circumstances that they were the one responsible.
Precisely. The running away, the timing, the blood tags, those are the circumstantial facts from which you infer the fact and issue who did the stabbing. That distinction between direct and circumstantial is fundamental.
Very clear. Okay, next term. Testimony.
This one's straightforward. Testimony just means the oral statements made by a witness in court while they're under oath or affirmation. It's how most witnesses give their evidence.
Okay. Documentary evidence.
Again, fairly self-explanatory. Evidence presented in the form of a document. This covers a huge range. Contracts, letters, emails, text messages, diaries, business records, police notebooks, basically anything written or recorded in a document format.
Got it. Real evidence.
Real evidence refers to physical objects that are produced for the court to inspect. Tangible things.
Such as?
The alleged murder weapon, the stolen goods, a piece of clothing with forensic evidence on it, fingerprints lifted from a scene, the actual CCTV recording shown in court. These are all examples of real evidence. The thing itself is the evidence.
Okay. Next, hearsay. The source flags this as complex, but gives a basic definition.
Yes, and we'll spend a lot more time on hearsay later. It's a major topic.
Yeah.
But the foundational definition is an out-of-court statement, something said or written outside the current court proceedings, which is offered in court to prove the truth of the matter stated in it.
And linking back to relevance, whether it is hearsay depends entirely on that purpose, right? Are you asking the court to believe the statement's content is true?
Exactly. That purpose is key. If you're offering it for some other relevant reason, like proving the speaker's state of mind, or that the words were simply uttered, it's not hearsay.
Okay. And the last term on the list, collateral facts.
Collateral facts. These are facts that are not themselves facts in issue. They're not the main points the case is about. However, they are relevant to something else important, usually either the credibility of a witness.
Like whether the witness has lied in the past or has a reason to be biased?
Yes, exactly. Things that affect whether the jury should believe their testimony. Or collateral facts might be relevant to the admissibility of another piece of evidence. For instance, facts needed to establish if a confession was voluntary.
And the source mentions this links to the collateral finality rule.
It does indeed. We'll pick up that connection when we discuss the course of testimony later. But for now, just know collateral facts are relevant side issues, mainly about credibility or admissibility.
Okay, fantastic. That vocabulary list is crucial. Facts in issue, direct, circumstantial, testimony, documentary, real, hearsay, collateral facts. You really need to be comfortable with those terms.
Absolutely. It's the language you need to speak to understand evidence law properly.
Yeah.
Learn them.
Right. We've got the core concepts, relevance, weight, admissibility, and the key terminology. Now, let's zoom out a bit and consider the theoretical context. The source materials really push us to think about the why. Why are the rules the way they are? What values are they trying to uphold?
This is so important for developing a deeper critical understanding. It's about moving beyond just knowing what the rule is, to understanding why it exists and whether it's achieving its aims. The source suggests you keep coming back to this section.
And the starting point, the most obvious aim, is getting the facts right.
Yes, most commentators agree that a core objective of evidence law is accurate fact-finding. You want the court to reach the correct conclusion about what actually happened. Jeremy Bentham, the famous legal philosopher, called this the pursuit of rectitude of decision-making.
Rectitude of decision-making sounds good. But the source immediately says, hold on, it's not just about finding the truth.
Exactly. And this is where the real tension and complexity lie. While accurate fact-finding is vital, it's not the only value in play. There are other important principles that evidence law tries to serve, sometimes even at the expense of admitting relevant evidence.
Such as?
Things like ensuring fairness to the accused, especially in the criminal justice system where the state has so much power, protecting fundamental human rights, maintaining the moral integrity and public confidence in the justice system itself. These are all major considerations.
So it's a balancing act, finding the truth, but doing it in a way that's fair and respects rights and maintains legitimacy.
Precisely. And often these values pull in different directions. There's a constant debate. Is a particular rule primarily about ensuring evidence is reliable, serving the truth-finding goal? Or is it about protecting some broader principle, like fairness or deterring misconduct, even if that means excluding evidence we know is reliable?
The source uses the example of evidence obtained unlawfully. That really highlights the conflict, doesn't it?
It's a perfect example. Imagine the police illegally bug a suspect's home and get a clear confession. That confession is probably very reliable evidence of guilt.
Yeah, seems like strong evidence.
But should it be admitted? Is the primary concern its reliability? Or is the primary concern the principle that the state shouldn't break the law, violating privacy rights, Article 8, to get evidence? Should we exclude it to deter the police from doing this again, even if it means a guilty person might walk free?
That's a fundamental clash of values right there. Truth versus principle.
It is. And because case law often reflects judges trying to navigate these competing values, you don't always find a single consistent line of reasoning. Different judges might prioritize different values in similar situations. Being able to spot these underlying tensions is key to critically analyzing evidence law.
To help us think about these clashes, the source outlines 3 basic lines of argument or theoretical perspectives we can use.
Yes, these are really helpful analytical tools. First, there are rights-based arguments.
Okay, focus on individual rights.
Exactly. These arguments evaluate evidence rules by asking, do they uphold or infringe fundamental rights? Particularly rights under the European Convention on Human Rights, like Article 6, right to a fair trial, and Article 8, right to privacy. Also, the right against self-incrimination is a big one here. Does the rule protect the individual?
Okay, rights-based. What's the second type?
Consequentialist arguments. These look at the likely practical outcomes or consequences of having a particular rule.
So what will happen if we admit or exclude this type of evidence?
Right. Will admitting it lead to more convictions of the guilty? Will excluding it effectively deter police misconduct? Will it make trials longer or shorter? Will it encourage witnesses to come forward or silence them? It's all about the real-world effects and achieving desirable outcomes. It's very policy-oriented.
Makes sense. Rights-based, consequentialist, and the third.
Arguments based on the moral legitimacy of the verdict. This is perhaps the most profound perspective.
Moral legitimacy. What does that focus on?
It asks whether the process by which the evidence was gathered and the verdict was reached was fundamentally just and fair, regardless of the outcome. Does the process uphold the integrity and moral authority of the justice system itself? Can the public have confidence in a verdict obtained through unfair or unethical means?
So, even if the verdict seems factually correct, if the way we got there was deeply flawed, the verdict itself lacks more legitimacy, like the ends don't justify the means.
That's the core idea. A conviction based on evidence obtained through torture, for example, might be factually accurate, but many would argue it's morally illegitimate because the process was corrupt. The system's integrity matters as much as the result.
The source mentions an article by Rebecca Helm here, The Anatomy of Factual Error, Miscarriages of Justice in England and Wales.
Sure.
A 50-year review. Can you say that title again?
Sure. Rebecca Helm, The Anatomy of Factual Error, Miscarriages of Justice in England and Wales, a 50-year review.
And what did her research show? Why is it relevant here?
Helm analyzed 250 miscarriages of justice since 1970, where the problem was identified as a factual error, basically.
Yeah.
The court got the facts wrong because of problems in evaluating the evidence.
So looking at real-world mistakes.
Exactly. Her work highlights the common culprits, things like unreliable eyewitness identification, false confessions, flawed expert evidence. It provides empirical grounding for why we have strict rules around admitting and handling these types of evidence. These rules aren't just theoretical, they're practical safeguards aimed at preventing those very factual errors that lead to innocent people being convicted.
That really brings home the importance of these rules. The source includes an activity, Activity 2.2, involving Adolphus Griggs and D.C. Goodall. It seems designed to make us apply these different theoretical arguments.
Yes, it's a very stark scenario, deliberately provocative. D.C. Goodall unlawfully enters Griggs's room, looking for evidence of a crime. He demands Griggs hand over a coat and knife. Griggs refuses.
Then it gets worse.
Much worse. Goodall assaults Griggs, breaks his arm, and threatens more violence unless he complies. Under duress, fearing further harm, Griggs gives Goodall a blood-stained coat and knife. The prosecution now wants to use this coat and knife as evidence against Griggs.
Okay, a really extreme example of improperly obtained evidence. Let's apply those three theoretical lenses. First, a consequentialist argument for admitting the evidence.
Well, focusing purely on the desired outcome of convicting someone potentially guilty of a serious crime, the argument would be, the evidence, the coat and knife, is highly relevant and likely reliable. Admitting it significantly increases the chance of securing a conviction, which serves public safety. That's the consequence they'd focus on.
Okay. Now, a consequentialist argument against admitting it, thinking about negative consequences.
The argument here would be that admitting evidence obtained through such blatant illegality and violence sends a terrible message. It could encourage police to cut corners or use force, knowing they can still use the evidence. It might undermine public trust, deter cooperation with police in future, and ultimately damage the long-term effectiveness and legitimacy of law enforcement. Excluding it, conversely, might deter future misconduct.
Makes sense. Now, the rights-based argument against admission, this seems pretty strong here.
Extremely strong. Griggs' fundamental rights were clearly violated. His right to bodily integrity, freedom from assault, under the common law and potentially Article 3 ECHR, prohibition of torture and human treatment, was breached. His right against self-incrimination was likely violated by being forced to provide evidence against himself. The initial entry was unlawful, potentially breaching Article 8 privacy rights. A rights-based argument would say the state cannot profit from its own violations of fundamental rights. Admitting the evidence would endorse those violations.
And finally, the argument based on the moral legitimacy of the verdict again, arguing against admission.
This perspective argues that a conviction obtained using evidence extracted through such brutality is fundamentally tainted, regardless as whether Griggs is actually guilty. The means used are so abhorrent, so contrary to the principles of a just legal system, that relying on them to secure a conviction undermines the entire moral authority of the court and the verdict. The process itself is illegitimate, therefore the outcome cannot be legitimate.
Wow. That Griggs scenario is incredibly powerful for showing how these different values, consequences, rights, legitimacy clash in practice. It's not just abstract theory.
Not at all. It forces you to confront the really difficult trade-offs involved in evidence law.
The source also poses some other self-assessment questions in this theory section, like why does English law generally assume the worst outcome is convicting an innocent person?
This really reflects a deep historical and philosophical commitment to individual liberty. The principle, often attributed to Blackstone, is that it is better that 10 guilty persons escape than that one innocent suffer. It underpins the high standard of proof in criminal cases, beyond reasonable doubt, and the fact the burden of proof rests entirely on the prosecution. It's a deliberate choice to err on the side of caution to protect the individual against the power of the state.
And what about equality of arms? Why is that a challenge, and how does evidence law try to help?
Equality of arms is a key part of the right to a fair trial under Article 6 ECHR. It means, ideally, the prosecution and defense should have a reasonably balanced opportunity to present their case. It's a challenge because, realistically, the state, with police, forensic labs, lawyers, usually has far greater resources and power than an individual defendant.
So how does evidence law try to level the playing field, even partially?
It does so through various rules that provide protections for the defense. Things like strict rules on the admissibility of confession evidence, limitations on using a defendant's previous bad character against them, disclosure rules requiring the prosecution to share evidence, and, again, the burden and standard of proof resting on the prosecution. These rules attempt to mitigate the inherent imbalance, though achieving true equality is often very difficult.
How does evidence law demonstrate the integrity of the criminal process, and how could a system lose its moral authority?
Integrity is shown through rules designed to ensure fairness, transparency, and reliability. Rules allowing cross-examination to test evidence, rules requiring a corroboration for certain types of evidence, rules excluding evidence obtained unfairly. These all contribute to the perceived integrity of the process. A system loses moral authority when it consistently ignores these principles, when it relies on unjust or coercive methods, prioritizes convictions over fairness, or fails to hold state actors accountable for misconduct. Public trust evaporates.
But the source also asks, why does public confidence also depend on convicting the guilty? It's not just about protecting the innocent.
True. While protecting the innocent is arguably the primary concern, a justice system that consistently fails to hold guilty people accountable also loses public confidence. People need to feel that the system provides justice for victims, maintains social order, and effectively addresses crime. It's a constant balancing act, achieving justice effectively, but always fairly and ethically.
Thinking about these issues, using those three lenses, rights, consequences, legitimacy, is just so important for understanding the why behind the rules you'll encounter later.
It really provides the critical framework you need.
And these values, these debates, are now heavily influenced by human rights law. So let's shift focus to the impact of the European Convention on Human Rights and the Human Rights Act 1998.
Yes, this has had a profound impact on evidence law, particularly since the Human Rights Act, the HRA, came fully into force back in October 2000.
And the source makes a really important clarification up front about Brexit, doesn't it?
Yes, it's crucial to understand this. The UK leaving the European Union is entirely separate from its membership of the Council of Europe and its commitment to the European Convention on Human Rights, ECHR. The UK remains a signatory to the ECHR, and the Human Rights Act 1998 is still part of UK domestic law. Brexit didn't change that.
Okay, good clarification. Which ECHR articles are most relevant for evidence law?
The big ones are Article 6, which guarantees the right to a fair trial. This comes up constantly. In Article 8, the right to respect for private and family life, home, and correspondence. Article 8 is often relevant when evidence has been obtained in ways that intrude on privacy, like surveillance or search of property.
Article 6 and Article 8. And the European Court of Human Rights in Strasbourg, how does it interpret these rights?
The ECTHR takes what's called a living instrument approach. The convention isn't seen as static. Its meaning evolves over time to reflect societal changes. They also tend to look at the overall fairness of proceedings rather than applying rigid rules, even for rights that seem absolute. It's quite a flexible, context-dependent approach.
Okay. So how does the HRA 1998 bring the ECHR into UK law? How does it require our domestic courts to handle convention rights?
The HRA fundamentally changed things. Before the HRA, the ECHR was international law, not directly enforceable in UK courts unless Parliament had specifically incorporated it. The HRA requires public authorities, including courts, to act compatibly with convention rights, and, crucially, it imposes a duty on courts regarding legislation.
What's that duty? The source outlines a kind of three-stage process.
That's right. It's a vital interpretive schema. Stage 1. The court looks at the relevant UK legislation. Does it, interpreted in the normal way, appear compatible with the ECHR? In doing this, under Section 2 of the HRA 1998 S.2, courts must take into account the case law of the ECTHR in Strasbourg.
Okay, take Strasbourg rulings into account under S.2. If it looks compatible, fine. What if it doesn't?
Then we move to Stage 2. This engages the very powerful interpretive obligation under Section 3 of the HRA 1998. Section 3, Schedule Point 3 states that, so far as it is possible to do so, primary legislation and subordinate legislation must be read and given effect in a way which is compatible with the Convention rights.
So far as it is possible to do so, that sounds quite strong.
It is incredibly strong. Courts must go to great lengths to find a convention-compatible meaning, even if it strains the ordinary language of the statute. They can use techniques like reading in words that aren't there, reading out words that are, or giving words a narrower meaning reading down to achieve compatibility. It's a major tool for aligning UK law with human rights standards.
So judges can effectively rewrite legislation under S.3 to make it fit the ECHR.
Within limits. The interpretation must still be possible. If Parliament's intention to create an incompatible law is absolutely clear and unambiguous, and no amount of interpretive gymnastics under S.3 can fix it without contradicting the fundamental thrust of the statute, then S.3 cannot be used. In that rare situation, we move to Stage 3.
Stage 3, the last resort. Section 4 of the HRA 1998.
Correct. Section 4, Heirs Point 4, allows higher courts, like the High Court, Court of Appeal, Supreme Court, to issue a declaration of incompatibility. This is a formal statement that a particular provision of legislation is incompatible with a convention right.
Does that strike the law down?
No, crucially it doesn't. A declaration of incompatibility under S.4 does not invalidate the law. The incompatible legislation remains legally in force. However, it sends a very strong political signal to Parliament that the law needs to be amended to comply with the UK's international human rights obligations. It usually triggers a process for Parliament to fix the law.
Okay, so the HRA gives courts this powerful S.3 tool to interpret laws compatibly, and if that fails, the S.4 power to flag incompatibility to Parliament, but not to invalidate laws directly.
Exactly. And as the source stresses, this whole S.2, S.3, S.4 interpretive framework is absolutely fundamental. You'll see it cropping up again and again when you look at specific evidence rules and how they interact with human rights.
Right. Concepts, terminology, theory, human rights impact. That's a solid foundation. Now, let's ground all this in the practical reality, the procedural context. Where and how does all this evidence law actually get applied?
Well, it plays out primarily in the trial process and also on appeal within the court system of England and Wales. And for the purposes of studying evidence law in depth, the main focus is usually on criminal trials taking place in the Crown Court.
Why the Crown Court specifically?
Mainly because that's where trials for more serious criminal offenses are heard before a judge and, crucially, a jury. The presence of the jury has historically driven the development of many complex evidence rules. The law aims to control the information lay jurors hear to prevent prejudice, ensure fairness, and guide them appropriately.
How do things differ in, say, civil trials or magistrates' courts?
In civil trials, heard mostly by a judge alone under the CPR, the rules of evidence are considerably more relaxed, as we mentioned with the judge's broad discretion under CPR 32.12. The judge is trusted to evaluate evidence appropriately without the same strict filters needed for a jury. In magistrates' courts, which also handle less serious criminal cases without a jury, judges or lay magistrates decide, the formal rules of evidence might apply, but often the practice is different, again because there's no jury to protect. The source confirms your exam focus won't be specifically on magistrates' court procedure.
Okay, so Crown Court criminal trials are the main stage for evidence law in action. The source mentions the criminal procedure rules, Crupus Crim, and the criminal practice directions, CPD, as key procedural guides.
Yes, these are essential. The CRIMPR are the detailed rules governing the practice and procedure in criminal courts. They're made under powers delegated by Parliament in the Courts Act 2003 and are frequently updated. They're now published together with the CPD in one consolidated volume.
And are there specific parts of the CRIMPR we should particularly be aware of for evidence?
The source highlights several key parts relevant to this course. Part 1 covers the overriding objective of the rules, which includes dealing with cases justly. Then you have specific parts dealing with types of evidence. Part 19 on expert evidence, Part 20 on hearsay evidence, Part 21 on evidence of bad character, and Part 22 on evidence relating to a complainant's sexual history.
Okay, good to know those numbers. CRIMPR's Parts 1, 19, 20, 21, and 22. What about the criminal practice directions, CPD?
The CPD are issued by the Lord Chief Justice. They used to be just guidance, but now they have statutory authority under Section 74 of the Courts Act 2003. They provide really useful, practical summaries of the law and authoritative guidance on how the CRIMPR and substantive law should be applied in practice.
Is there a specific CPD part relevant here?
For this course, the source specifically flags paragraph 7 of the Consolidated CPD, which gives detailed guidance on handling expert evidence, linking to Crimpar Part 19.
Okay, so the Crimpar and CPD set out the procedural rules. Left will walk through the actual process of how evidence, particularly from witnesses, is presented in a typical Crown Court trial, the course of testimony.
Right. The usual order is that the prosecution presents its entire case first. They call all their witnesses. Then the defense has the opportunity to present its case, which may involve calling defense witnesses.
And for each witness called by either side, there is a standard sequence of questioning.
Yes, typically 3 stages for each witness.
Stage 1 is examination in chief.
Correct. This is also sometimes called direct examination. It's conducted by the lawyer, counsel for the party, who called that witness to give evidence. The aim is to elicit the witness's testimony that supports that party's case, getting their story out in a structured way.
And this is where the famous rule against leading questions primarily applies, isn't it?
Yes, absolutely. In examination in chief, you generally cannot ask leading questions. A leading question is one that suggests the answer the lawyer wants to hear, or assumes a disputed fact. Like, you saw the defendant running from the building at 10 p.m., didn't you?
Why are they banned here?
Because the witness is generally expected to be favorable, or at least not hostile, to the party who called them. Allowing leading questions would basically let the lawyer put words into the witness's mouth, making the evidence seem rehearsed or unreliable. You want the witness's own account, prompted by open questions like, what did you see next?
Makes sense. Get the witness's story, not the lawyer's. The source notes a difference in civil trials, though.
Yes, in civil cases, procedure under the CPR is different. CPR Rule 32.5-15-2 allows a witness's pre-prepared written statement, their witness statement, to often stand as their evidence in chief. They'll still likely be cross-examined orally, but their main evidence is often put in writing first.
Okay, so after examination in chief, what's the next stage?
Cross-examination. This is conducted by the lawyer for the opposing party. If there are multiple defendants, their lawyers might also cross-examine a prosecution witness, or indeed, a co-defendant's witness.
And what's the purpose of cross-examination?
It has several key objectives. One is to undermine the testimony given in examination in chief, perhaps by highlighting inconsistencies, weaknesses, or suggesting the witness is mistaken or lying. Another is to elicit testimony that actually supports the cross-examining party's case. A third crucial purpose is to put your case, to put your client's version of events to the witness for them to confirm or deny.
And the scope is wider than examination in chief.
Much wider. Cross-examination is not limited to matters raised in examination in chief. It can cover any issue relevant to the case or relevant to the witness's credibility.
And crucially, leading questions are permitted in cross-examination.
Yes, they absolutely are. Because the witness is generally presumed to be adverse or at least not aligned with the cross-examiner, leading questions are allowed as a way to challenge them directly and probe their evidence effectively.
Can you also attack the witness's character or reliability?
Generally, yes. Questions designed to discredit the witness by suggesting they are untruthful, biased, have poor memory, or their perception was impaired are usually permitted in cross-examination, as credibility is always relevant. However, there are important statutory restrictions in certain sensitive areas, which the course will cover later, specifically regarding the cross-examination of complainants in sexual offense cases about their sexual history, and restrictions on using witnesses, including the defendant's bad character.
Okay, so some limits, but generally wide scope, leading questions allowed, credibility can be attacked. Now, the source introduces a really important rule here related to attacking credibility. The collateral finality rule. Can you explain that again?
The collateral finality rule, yes, this is a tricky but vital concept. It applies when a lawyer is cross-examining a witness only on matters that are collateral. Remember, collateral facts.
Yeah, facts relevant only to the witness's credibility, not to the main facts in issue of the case itself.
Exactly. The rule states that if you cross-examine a witness on a purely collateral matter, something relevant only to their credibility, you are generally bound by their answer. Their answer is considered final.
Meaning what? Exactly. Bound by their answer.
It means you cannot then call your own separate evidence, adduce rebuttal evidence, just to contradict the witness's answer on that collateral point.
So if I ask a witness, isn't it true you were convicted of perjury 5 years ago? Assuming that's only relevant to their credibility in this trial. And they say, no, that's not true. I can't then call a court official or produce a record to prove they were convicted of perjury.
Under the basic collateral finality rule, no, you couldn't. Their denial on that purely credibility-related issue would be final. You could certainly argue to the jury later that you don't believe the witness's denial
Right.
based on their demeanor or other evidence, but you wouldn't be allowed to introduce new evidence specifically to disprove that one collateral answer.
Why does this rule exist? Seems a bit odd.
The policy reason behind it, as the source explained, is primarily practical. It's to prevent trials from getting completely sidetracked. If parties were allowed to call evidence to disprove every single answer a witness gave on any matter touching their credibility, however minor, trials could descend into endless mini-trials about side issues.
Yeah, you'd get bogged down in satellite litigation, as the source calls it.
Exactly. It would confuse the jury, waste court time, and increase costs enormously. The rule aims to keep the focus on the main facts and issue.
Okay, that makes sense from a practical viewpoint, but are there exceptions? The source mentioned one key one we need to know now.
Yes, there are exceptions, and the main one you need to know at this stage relates to proving a witness has made a previous inconsistent statement. This is covered by Section 4 of the Criminal Procedure Act 1865. Remember that. S.4 Criminal Procedure Act 1865.
Section 4, CPA 1865. What does it allow?
It specifically allows a cross-examining party, if a witness denies making a previous statement that contradicts their current testimony, to introduce evidence to prove that the witness did indeed make that prior inconsistent statement.
Ah, so if a witness testifies the light was green in court, but you have evidence they told the police earlier the light was red, and they deny saying that to the police, you can call the police officer or produce the statement to prove the inconsistency.
Yes. That's the effect of S.4 CPA 1865. It's a major exception to the collateral finality rule, because a direct contradiction on a relevant matter goes so fundamentally to the witness's reliability in this case that the law allows it to be proven independently.
Okay, that's a crucial exception. Collateral finality rule. Generally accept the answer on credibility issues, unless it's about proving a prior inconsistent statement under S.4 CPA 1865. Got it. What's the third and final stage of examining a witness?
Re-examination. This takes place after cross-examination is finished. It's conducted by the counsel who originally called the witness, the one who did the examination in chief.
And what's the purpose of re-examination?
Its sole purpose is to repair any damage done during cross-examination,
Hmm.
or to clarify any ambiguities or misunderstandings that arose as a result of the cross-examination.
So if the cross-examination left a misleading impression, the lawyer who called the witness gets a chance to try and clear it up.
Exactly. For example, if cross-examination forced the witness to give a yes or no answer that needs context, re-examination can provide that context. However, it's very strictly limited in scope.
How so?
You absolutely cannot use re-examination to introduce completely new topics that you forgot to cover in examination in chief. It must arise out of matters discussed during cross-examination. And generally, leading questions are not permitted in re-examination, just like in examination in chief.
Okay, so examination in chief, your witness, no leading questions. Cross-examination, opponent's witness, leading questions allowed. Wide scope, including collateral finality rule. And re-examination, your witness again, only to clarify cross-examination points, no leading questions. That's the standard flow.
That's the basic structure, yes.
No, shifting focus slightly within procedure. The source talks about the role of the judge, trial rulings, and specifically highlights the submission of no case to answer. Let's focus on that submission section 2.4.1.3. Why is it so important?
The submission of no case to answer is a really critical procedural checkpoint in a criminal trial. It happens at a specific point, right after the prosecution has finished presenting all of its evidence and before the defense starts its case, if it chooses to.
And what exactly is the defense doing when they make this submission?
They are arguing directly to the judge, not the jury, that the prosecution's evidence, even if you take it at its absolute highest and assume it's all true, is legally insufficient to support a conviction. They're saying, Your Honor, based on what the prosecution has shown, no reasonable jury properly directed could possibly convict. There is simply no case for us to answer.
And if the judge agrees with the submission?
If the judge upholds the submission of no case to answer, that's the end of the trial. The judge directs the jury to acquit the defendant, and the defendant walks free without the defense having to present any evidence at all.
Wow. So understanding this helps us understand how judges act as a filter, assessing the legal strength of the prosecution's case.
Exactly. It shows the judge evaluating whether the evidence crosses a minimum legal threshold before it even gets to the jury for them to decide on the facts and guilt. Understanding this process is particularly helpful when you later study specific types of potentially weak evidence, like eyewitness identification or certain types of hearsay, because the no case to answer submission is often where challenges to the sufficiency of such evidence are made.
What's the actual legal test the judge applies when deciding if there's a case to answer?
The crucial test is known as the Galbraith test. It comes from the Court of Appeal case of Galbraith, 1981, 1 WOL, so 39. You really need to know this case name and test.
The Galbraith test, from the case Galbraith. Got it. Is it a single test?
It's usually described as having two limbs, depending on the nature of the prosecution's evidence. The first limb applies where the prosecution case depends on direct evidence.
Okay, what's the test if there's direct evidence, like the eyewitness saying, I saw him do it?
In that situation, the Galbraith test says that if there is some direct evidence which, if accepted by the jury, would be capable of proving the charge, then there is a case to answer. The judge should not stop the case at this stage, no matter how weak or unreliable they personally think that direct evidence is.
So if the evidence is capable of proving guilt, its credibility and weight are purely matters for the jury.
Essentially, yes, when it's direct evidence. The judge's role is just to assess legal capability, not factual reliability. However, the second limb of the Galbraith test applies where the prosecution case relies wholly or mainly on circumstantial evidence. This limb is more complex.
Okay, what's the Galbraith test for a purely circumstantial case?
Here, the judge has to undertake a more evaluative assessment. The question becomes, is the circumstantial evidence taken at its highest, i.e. assuming the jury believes it and draws the inferences most favorable to the prosecution, such that a jury, properly directed, could reasonably conclude that the defendant is guilty beyond reasonable doubt?
Could reasonably conclude guilt. That sounds like the judge is assessing the potential weight or strength a bit more.
Yes, in a way. The judge has to consider whether the circumstantial evidence is capable of leading to only one reasonable inference, guilt, or whether, even on the prosecution's best showing, there remains a reasonable possibility or hypothesis consistent with innocence that a jury couldn't reasonably exclude.
So if the circumstantial evidence is weak or points equally to innocence as to guilt, the judge should stop the case.
Exactly. If, even assuming all the prosecution's circumstantial evidence is accepted, a reasonable jury could not properly convict, because guilt beyond reasonable doubt isn't a possible conclusion, or because reasonable innocent explanations haven't been ruled out, then there is no case to answer and the judge must direct an acquittal.
That's a crucial difference between how direct and circumstantial evidence are treated at this stage. The source mentions a couple of other cases here.
Yes, it points to Sardar, 2016, EWCA Crim, 1616. In Sardar, the Court of Appeal, led by Sir Brian Levison P., discussed the application of the Galbraith test to circumstantial evidence and approved an Australian judicial statement as correctly reflecting the English law approach. Sardar.
And it also mentions ABV CPS 2017, EWHC 2963 again.
Yes, ABV CPS as a straightforward example of the law, including these procedural points being applied. These cases help illustrate the Galbraith test in action.
Understanding the submission of no case to answer and the Galbraith test is clearly vital for seeing how evidence law works procedurally.
Absolutely. It's a key part of the trial process where legal sufficiency is tested.
Okay, so after all the evidence is presented, assuming the case survives any no case submission, and the lawyers have made their closing speeches, the judge has another crucial procedural role. The judge is summing up and directions to the jury. Section 2.4.1.4.
Yes, the summing up is critical. This is where the judge performs two main tasks. First, they summarize the evidence that has been presented by both the prosecution and the defense, focusing on the key points relevant to the facts in issue.
Kind of reminding the jury what they've heard.
Exactly. And second, and arguably more importantly, the judge must give the jury directions on the relevant law they need to apply to the facts as they find them in order to reach their verdict. They explain the elements of the offense, the burden and standard of proof, and any specific legal rules or warnings relevant to the evidence heard, like how to approach identification evidence or lies told by the defendant.
The source mentions the Crown Court Compendium here.
Yes, the compendium provides standard templates and guidance for judges on how to direct juries on various points of law and evidence. But the source rightly stresses that judges shouldn't just read mechanically from the compendium. They must tailor their directions very carefully to the specific facts and issues raised in the particular trial they are presiding over.
And we'll encounter specific types of jury directions when we study specific evidence topics later.
Yes, things like directions on hearsay, bad character, expert evidence, they all have specific guidance on what the judge needs to tell the jury.
Okay. So the trial concludes with the jury's verdict, but that might not be the end of the story. Let's talk briefly about appellate review, section 2.4.2. How can convictions be challenged later?
Most of the evidence law cases you'll read in your studies will be decisions from the Court of Appeal, Criminal Division. A defendant who is convicted in the Crown Court can seek leave to appeal against their conviction.
On what grounds? Usually related to evidence.
Often, yes. Common grounds for appeal include arguing that the trial judge made an error of law, perhaps by wrongly admitting evidence that should have been excluded, or wrongly excluding evidence that should have been admitted. Or the judge might have misdirected the jury on the law or failed to give a necessary warning about certain evidence.
But just finding an error by the judge doesn't automatically mean the appeal succeeds and the conviction is overturned, right?
No, not automatically. The ultimate test for the Court of Appeal under the Criminal Appeal Act 1968 is whether the conviction is unsafe. Even if the trial judge made a mistake, the Court of Appeal might still uphold the conviction if they believe the error was minor and couldn't possibly have affected the jury's decision, for example, if the rest of the prosecution evidence was absolutely overwhelming.
They ask, would the jury have convicted anyway, even without the error?
That's often a key question, yes. However, the concept of safety is increasingly influenced by human rights law, particularly Article 6 ECHR, the right to a fair trial. The courts have recognized that a conviction resulting from a trial process that was fundamentally unfair might be deemed unsafe under domestic law, even if the evidence of guilt seems very strong. A significant legal misdirection or a serious procedural irregularity that breaches Article 6 fairness principles makes it much more likely the Court of Appeal will quash the conviction, regardless of perceived guilt. The fairness of the trial itself is paramount.
So Article 6 adds another layer to assessing the safety of the verdict.
It does, although the source also notes a potential countertrend identified by commentators like Roberts and Zuckerman. Sometimes, the fact that trial judges now have more discretion, for example under Pace East S.78, might make the Court of Appeal more reluctant to interfere, showing more deference to the trial judge's assessment of fairness on the ground. It's a complex area.
But regardless, these Court of Appeal decisions are incredibly important for us as students.
Absolutely crucial. They are the primary source for understanding how the rules of evidence are interpreted, applied, and developed in practice. You'll be reading a lot of them.
Okay, that makes sense. And that really brings us towards the end of this foundational deep dive. We have covered a huge amount of ground today.
We certainly have. We started with those absolute pillars: relevance, weight, and admissibility. Understanding how they're different but interconnected is key.
Then we build up our essential vocabulary facts and issue: direct versus circumstantial evidence, testimony, documentary, real, hearsay, collateral facts. You need that language.
We explored the why, the theoretical context, the goal of accurate fact-finding versus protecting rights and legitimacy, and those useful analytical tools: rights-based, consequentialist, and legitimacy arguments.
We saw the massive impact of human rights law, ECHR Articles 6 and 8, brought into UK law by the HRA 1998 with that vital S.2, S.3, S.4 interpretive process for courts.
And finally, we walked through the practicalities, the procedural context of a Crown Court trial, the stages of examining witnesses, including that tricky collateral finality rule and its S.4 exception for inconsistent statements, the crucial submission of no case to answer, and the Galbraith tests, the judge's summing up, and how appeals work.
These basic concepts, this framework, this vocabulary, it truly is the absolute foundation for everything else you learn in the law of evidence. Getting to grips with this now will make navigating the complexities ahead so much clearer.
Definitely. You can't understand the exceptions to hearsay if you don't understand what hearsay is or why relevance matters for it. It all builds from here.
Think of it like learning the scales before you play a symphony. You need these fundamentals.
That's a good analogy. And as you go forward in your studies, keep wrestling with that core tension we discussed. That balance between the need for accurate fact-finding, convicting the guilty, protecting society, and the equally vital need to protect individual rights, ensure fairness, and maintain the system's integrity.
Where should the balance lie when deciding what evidence gets heard? It's not always easy, and it's the question the law is constantly grappling with. Something for you to keep thinking about.
And before we finish, we absolutely must thank the University of London again for making these excellent educational resources available to students.
Yes, thank you to the University of London, and thanks also to Sinorbit Academy Sri Lanka for bringing you this deep dive.
Remember, this is all for educational purposes, designed to help you understand these crucial concepts. Keep revisiting this material as you progress through the subject.
Absolutely. And one last time to everyone listening and studying hard, especially if you have exams coming up, the very best of luck from both of us.
Good luck. Keep digging deep into the material.